I think I made it very clear during trial that I don't take this lightly at all. I know the loss that the families have experienced. I know the devastation that the families have experienced, the other victims of the shooting, the school in general, the community as a whole. This is not something that I've taken lightly. It's not anything that I have been inconsiderate of. However, having said that, I don't believe that James is guilty of involuntary manslaughter. He didn't know what his son was planning. He didn't know a lot, as I said in my closing statement, and I stand by that. Everything that I said during trial, I stand by and I believe. I do feel terrible for those families. I feel horrible for the community. They have all experienced something that they can never forget, and losses that they can never get back. And it's not something that I've taken lightly throughout my representation of James. James also feels terrible for what happened. He feels terrible for the families who lost their children, for the individuals who were directly affected by the shooting at Oxford High School. That's something that I don't know if people realize, but it's very true. He feels terrible about it. He wishes that he had made different decisions that day. Unfortunately, we can't go back, and looking in hindsight, maybe different decisions could have been made. But what the jurors had to do was incredibly difficult. The things that they had to watch, and I said it in my opening and in my closing, that the things that they were going to see and hear during that trial were going to be incredibly difficult for them. And we knew that. I maintain that James did not do anything illegal in the storage of that firearm. In 2021, there were no laws regarding how that firearm is stored. He did not break any laws. I understand that that was an issue for the foreman, and that was his issue. But there wasn't anything illegal about it. And James didn't know what his son could or would do. He didn't know that his son even knew where that firearm was.
Can you give us any insight into what that relationship was like between father and son, and how he missed this?
They had a great relationship. They spent a lot of time together, and they talked a lot. And it was never made an issue to James. You all heard James's sister testify that within days of James's son saying that he was mentally and physically dying to a friend, that the sister and other family members saw him in another state, and he was fine. Nobody saw anything. So it wasn't just James. There were a number of people who didn't see anything. And I think that as a parent, you just don't see it sometimes. And I think that most parents can relate to that, whether they want to admit it or not. I think that there are signs missed all the time by parents that they just don't see. The only difference is that their children didn't do what James's son did, so it doesn't become such a big issue.
Is there anything that you would have done differently, and what do you think you did really well?
I don't think I would change anything. I think that the human factor in jurors is something that none of us can overcome as attorneys. And in Oakland County, people who were in many ways very directly affected by what happened at Oxford High School, I think that it's hard to overcome that. I believe that all 15 of the people that were sitting in that jury box truly believed on the first day that they could be fair and impartial. And then when faced with the decision of going one way or the other, it became a lot harder to be fair and impartial. They made the decision that they thought was right. Obviously, James and I are disappointed by the decision. I don't fault them. I don't at all. I don't envy what they had to do. And I think that it wore on their faces how difficult it was for them to sit through that trial for 2 weeks and make the decision that they made. But they did. I don't know that I would change anything. I don't think that I would change anything in the way that I approached the trial. Honestly, the hardest part about the gag order was watching all of the information, and I use that term lightly, that came out early on and not being able to refute it. There were a lot of interviews that happened. There were a lot of pieces of information that were leaked to the media that we couldn't refute. And we didn't want to try this case in the media. James didn't want this case tried in the media. We wanted it tried in the courtroom where it should have been tried. As the judge instructed the jury repeatedly during trial, that the court of public opinion doesn't have rules. It's in the courtroom that the case should be tried. And unfortunately, I think that there were a lot of opinions formed early on that may not have been able to be overcome about James and Jennifer Crumbley.
Why didn't James take the stand?
He has the right to remain silent. And we decided that he wasn't going to testify. He wanted to remain silent. He said all the things that we felt he could say on the stand in police interviews and on video and everything else, so the jury got to hear from him, which doesn't always happen in trials. But they got to hear from him without him actually having to take the stand. And again, as somebody who's accused of a crime, he has the right to remain silent. He doesn't have to testify. I'm hopeful that the families in the community can start to heal. I don't know that that's going to come anytime soon. But I do hope that they can start to heal now that, at least for now, these cases are ending. And they don't have to look at the comments or the articles or everything every couple of days to see, no offense to you all, but to see what you all are putting in the media about their children and their loved ones and the people who are accused of wrongdoing. I really do hope that they can find healing.